coffee was good. I would like to introduce the second chair of the second panel, our second chair, Michel Langlois. Michel Langlois is a Canadian jurist specialized in international human rights law as well as clinical legal education. During her time at UQAM, she served as a case manager at the CIDDHU and then as a coordinator of the CIDDHU. She also supervised the drafting of parallel reports on children's rights, gender-based discrimination, and violence in Southeast Asia and in the Caribbean. She has a special interest for Southeast Asia, and she has worked in Thailand and Cambodia. She is now a graduate from the LLM in International Human Rights Law from the University of Notre Dame, and she has worked since 2015 in New York at the NGO Shift. Thank you, Michel, and I will let you introduce our panelists tonight.
Thank you, Lily. So today, this panel will be partnering up for human rights. I'm not here to speak about Shift's experience with the CIDDHU. We currently have a project called the UNGP Reporting Database, focused on what companies have to say about their implementation of the UN Guiding Principles on Business and Human Rights. It is a very successful collaboration with the CIDDHU, but today we have other guests to speak about how they partnered up with clinical legal clinics and how they were able to produce some great products in terms of human rights advancement. So the first speaker is Duhaime. He is professor of law at the Faculty of Political Science and Law at UQAM. He was the founder and former director of the CIDDHU, and for his very impressive list of accomplishments, I will refer you to his bio in the main program. So here's Steve Bernard.
Merci Michel. C'est un honneur de partager cette table avec vous, ma chère. It's an honor to be here with you, and I'd like to thank the organizers of the event, in particular Nelia, Elise, and Stéphane. I also take this opportunity to reiterate my thanks, admiration, and friendship for Nelia Trich, who has been directing this clinic as a fantastic captain, as said my friend Nicolas. She has taken the clinic to new frontiers, as the Star Trek expression says. Creating an effect which I never thought would happen, was to attract extraordinary people and create an extraordinary team focusing on the potential and the great spirit of our former students. So now our network, our internal network, allows the clinic to develop itself, thanks to Miria's vision of partnering up not only with fantastic human rights defenders abroad, but with visionary young lawyers and professionals who want to change the world. And I think this was a fantastic idea. So thank you again for this. The second panel deals with cooperating or partnering up for human rights, and I've been asked to address the issue of how clinical research is done to the benefit or for the training of our partner organizations. Of course, there's a presumption in this project or discussion because we presume that clinics work with partner organizations. Of course, you know that several models of clinics and human rights clinics exist. Some of them are simply built around the simulation project, and rather than doing actual projects. Other clinics work with essentially the purpose of educating the public and working with citizens, street law clinics, for example, and other clinics work directly with victims or clients, so individuals. But other types of human rights clinics, and I guess it's the type of clinics that we have here today, work with partner organizations, and together we agree on a project, as you know, to be completed during a semester. Because of the academic limitations and logistical limitations that this implies, clinical professors hope to have and find a partner that will formulate with great pragmatism a fantastic legal question and will come with a pre-formatted project, and Clinique can complete this project in 14 weeks, and we have obtained a fantastic result. And this is, of course, conditional on finding a fantastic partner, and I take this occasion to salute and thank my good friend Anton, who is this type of ideal partner who comes up with these fantastic questions, and we're able to proceed really quickly, and we have developed this very close relationship where we know both of our potential and limits, so we're able to build these projects quite quickly. Sometimes the needs of the partner organization are not well defined, and we have to work with the partner organization to identify the needs and the research needs, and this might be a little bit more complicated. It requires more collaboration, and we need to assess the situation, the context, the needs, what can be done realistically. In some instances, the only type of clinical intervention that is required by the partner is to deliver what research has already been done by the partner. So Miria and I, we did a great project on Cambodia a few years back where 39 NGOs had already done the research on the ground, documenting the phenomenon of violations of economic, social, and cultural rights, and I asked the clinic basically to analyze the data and then present it in a format that would be usable by the international community. So, of course, all these scenarios present different challenges for clinics in terms of what research is done and how this has an impact on our beneficiaries or the partner organizations. Today I would like to essentially talk to a few examples on how our legal research projects have an impact on the partner organizations. I will then address whether this is part of the mission of a university. I will argue that it is, of course, and then close with a broader, more perhaps theoretical questions without referring to the sophisticated mythology of Greek gods, unfortunately. So, one type of project that we have done in terms of legal research that have had impacts, very positive impacts that stayed on for our partners, is to help partners define strategies. They come with a very general question and don't really know how to go about to address this. They have an intuition or sometimes an understanding that this is wrong, and that needs to be addressed. They find the limitations in their domestic environment, and they want to do something about it. So the project of the clinic that semester is essentially to try to understand the needs of the partners and to build a research question together and then try to answer it. So this raises all different types of substantive law issues, methodological issues. But for example, we worked with l'Action chrétienne pour l'abolition de la torture in Cameroon, who came to us with a problem dealing with the arbitrary detention of people who had served their sentences and were not freed. So we had to work on what type of problems this raises in international law, what type of fora they could go to address these questions. So through this advice, or this memo, or this guide, we were not only formulating a solution, but we were also training the partner on how to conceptualize a problem and to assess the problem and build a strategy. Another type of research-related action that has an impact on the beneficiary organization is, of course, directly working on the training of the staff or the team that the partner is building to undergo its work. We've had a fantastic partnership with an NGO in Haiti called CIDDHU, which works on violence against women in Haiti. And you know that in 2010 there was a terrible earthquake. Half of the staff of CIDDHU died in that earthquake. And one of the projects that we were asked to do was to train the new team, because they had to recruit 50% of their team. So we helped them. Of course, they continued to work on documenting violations of women's rights in Haiti, and it was a catastrophe because there were lots of sexual violence in the camps and so on. They did not have the time to deal with the human resources aspect of rebuilding their team. So we helped them through legal research to identify the substantive law issues, the methodology. We built a guide, and we then sent 2 students to go and present this guide. So our work, our research had an impact on the direct training of our students, our partner. Another type of research initiative that we did dealt with training our partners' organizations who work in human rights education and who themselves train different types of actors. And many of our partners have this among their actions, which is human rights education. Miria and her fantastic team recently just finished a report which was destined to a Guinean organization that will help them to train police officers to prevent and eradicate torture in Guinea. And this will help Guinea implement recommendations formulated by the Committee on Torture. So the students had to do the research on not only the substantive law on torture, but on how this can be implemented at the local level through police force programs and education programs and so on. So educating people to educate on human rights. Also, we had projects where the research required was destined to train partner organizations to observe and document human rights violations in order to do litigation or advocacy and so on. So building a methodology adequately tailored for the needs, the final needs of the advocacy expected. So we did a training and a guide for Equatorial Guinea organization that wanted to document the economic, social, and cultural rights violations generated by the exploitation of natural resources in Equatorial Guinea. And you know, this is very peculiar because documenting violations of economic, social, and cultural rights requires specific methodology, it's very complex and so on. Another type of research that has an impact on the beneficiary organization is the combination of the last two, which is training our partner organization to train people to observe and document human rights. So to decuplate the effect of the training so to document more violations. So we worked for a Colombian organization called Justice and Peace, which receives every year peace brigades, volunteers, and they observe violations of international humanitarian law by the army, by paramilitary, and by guerrilla forces in civilian areas. So they wanted to know how to train these people, these peace brigades, to document and observe these situations. So it's kind of a combination of the last two. Right? And finally, of course, we have worked, and many organizations do the same, in providing specific training and advice and expertise to organizations that want to use the international judicial or quasi-judicial institutions as the next step. Some of the partners that we work with are very familiar with their domestic laws and procedures, but less with international law procedures. In particular, considering that international judicial bodies often combine legal cultures that are different than the ones of our partner organizations. So international bodies often combine common law and civil law legal traditions in terms of evidence and procedure. So the clinic helped, for example, an NGO prepare the cross-examination of an expert in the Chita versus Guatemala case, where we had not only to prepare the cross-examination with the partner organization in terms of trial advocacy techniques. As you know, doing the cross-examination of an expert witness is a specific technique of trial advocacy. It requires the specific rules. And we needed to ourselves become experts in the field of expertise of the expert in order to be able to do a proper cross-examination, which required for us to do research on this specific area, which was reparations for human rights victims in domestic. Now, how do these examples fit in with the mission of a university? Universities, they train students, right? We do research. How does training indirectly beneficiary organizations fit with the university's mission? And I think it fits perfectly with the mandate of universities. I think universities not only train students, they train citizens. They train students to have an impact on society. The goal is to have a better society. It's not just to have intellectuals who do their work in a society and don't have an impact on society. So I think through clinical pedagogy and through a closer collaboration with the end receiver of our initiative, we should in fact find ways to put our pedagogical efforts at use for educating and helping our co-citizens finding solutions to their social problems. Now, this is precisely what UQAM was built for in the 70s. Not only to teach, but to teach to those who couldn't usually access to the superior education, and also to bring the university's resources to the population. It's not a coincidence that we are based, well, not here in the Quartier des Arts, but in now, the Université du Québec à Montréal for this has a fantastic jewel which very few know about, and it's called the Service aux collectivités. The union of the professors and the administration agreed together a while back that a certain number of teaching credits would be reserved for professors who, instead of teaching a regular class, would help an NGO from the community to either train their staff or their beneficiaries, or to do a specific research project that is used by the NGO. So instead of teaching one class, you get one teaching credit, which is obtained from this pool of classes that is administered by this service, the Service aux collectivités. And there's a process in order to attribute these teaching credits, and the partner organization needs to work with the professor and the service to build the research question or the training question, fix objectives, and assess the results. And it's a collaborative process from the beginning. It's kind of a clinical project, but at a larger scale. What's interesting is that at the clinic we were able to build a series of interventions through the clinical projects, but also having the help of this jewel, which is the Service aux collectivités. So, for example, we have been able to do all of the previous examples of types of training and elements on partners and benefits to partners through this Service aux collectivités projects. So we work with Femmes Autochtones du Québec and the Network of Indigenous Women of the Americas in order first to establish a strategy to address the issue of double or intersectional discrimination, which is when several factors of discrimination intersect and create a new form of human rights violation for indigenous women, right? So, of course, this is a very abstract concept, a very complicated concept. So we worked with them to assess what type of human rights violations this could do in the fields of housing, education, health, legal status, violence in general, and so on. And then we suggested different avenues. Then we were able to build a training program for the leaders of these organizations when we went to Kanawage, to Colombia, to Argentina, to Mexico, and we literally trained the leaders on these projects. Then we also built training programs so that these leaders could train the women in their communities to understand the issue or to better appreciate the dimension and the catastrophe of the violent discrimination that they live, and then to be able to identify these types of cases. We did this with 2 former students who had also worked with this clinical project in the past. We also provided our partner organizations in those 4 countries with methodologies to document the types of cases that we were looking for together in order to eventually litigate these cases. And we've sent students to Mexico, to Colombia, and to Argentina to do so. We were supposed to eventually litigate these cases, but we haven't so far because the documentation process has not succeeded so far. But we have done these types of training and this type of impact on our partner organizations in other litigation processes. You've heard of the Guayubin massacre case that we had won at the Inter-American Court in 2012. Well, thanks to the Service aux Collectivités, we were able, for example, to do a training on how to document human rights violations, go there, do 3 days of training on a methodology of fact-finding, going with them on the massacre site, interview with them the victims, and so on. Then we had a student who went there and completed this initiative using that methodology that we had established together. And then, of course, we did the trial, which also included a training and capacity building dimension because these lawyers had never done oral examination of witnesses and cross-examinations. And raising objections. If you look at the video, you will see that our Dominican lawyers were very excited at doing objection. They had not ever done this in their trials before. And then, thanks to another project of Service aux Collectivités, we were able to do a training on the implementation or on documenting the lack of implementation by the state of the trial that we had won, of the judgment. So we did again a guide. We managed to go to the Dominican Republic. We managed to discuss this with our partners and then send a student to document these events and this lack of implementation with them. So interestingly, all of these actions not only were for the benefit of our students and for the benefit of our partners, but it also trained our students to build action-based research projects with partners and develop this open-minded approach to building a solidarity and partnership-based research project. So that in itself also is another addition, not necessarily for the partner organizations, but for the methodology that our students learn. It had other incidents or indirect advantages, like contributing to legal scientific research in the more traditional sense, since in both of these projects, we were able with students to publish articles in law reviews, in the Quebec Law Journal and Miami Law Review, on more abstract theoretical issues related to intersectional discrimination and to racial discrimination in the DR. I will conclude by saying essentially 3 things. I think clinical legal education has great potential to strengthen the capacity of our partner organizations, and I think this is part of our objective, of our goal, of the philosophy, of the approach that we have of teaching law. I think, nevertheless, that we are failing in many ways, and we can do better. First, we tend to perceive our capacity to help the beneficiary only through legal research. And we are in a university. There are tons of experts in psychology, biology, chemistry, sociology, and these are all expertise that cost a lot of money for our partner organizations when they want to document stuff. We had a case that we wanted to bring before the ILO regarding land rights of an indigenous community in Guatemala. And we were not in charge of documenting the environmental impact of the gold mine on the river. This had been done by some other scientists. And the scientific study was not really excellent. But it could have been done in a clinical project with students from the biology and chemistry department. Or when in the Chitai or the Guayubin massacre case, we needed to assess the psychological damage of the violations on our clients, we could have worked on a clinical project with the psychology department. Why not? So I think clinics need to do better and broaden our collaboration and broaden our views, because this university has a lot of things to offer besides legal research. The second one is that I think we need to link our legal and other forms of research initiatives with what graduate students want to work on as a thesis, and help them think to take the issue that they have worked on to the next level. We can help them build interesting research questions and eventually publish those results at a second level. So I think we need to build stronger research-based initiatives between the clinic and the graduate programs. Third critic is that we need to discover the expertise of our partners. We tend to forget that our partners have more experience than we do. They risk their lives. They risk their families' lives. So we need to be more attentive to that and try to respect and be humble. I think we do, but we need to keep that in mind as we work with them. We've tried to do it in all our mandates at the CIDDHU, but I think we need to do better to understand these aspects. To conclude the conclusion, Michel, the benefits of this approach are twofold, very quickly. The first one is, of course, that we can develop research projects and questions with partner organizations and not do it in silos. This is very important because we learn from our partners, asking questions with them and finding solutions with them, and then establishing a methodology to answer these questions together. The second great benefit is that hopefully these partner organizations will no longer need the help of North American law clinics. They will be strengthened in their capacity. They will be more autonomous. And I'm sure my esteemed colleagues who are passionate about post-colonial studies would agree that clinical legal education fosters a transfer of knowledge and an empowerment, and makes human rights no longer a well-intentioned hobby of the white man, but a truly ground-based initiative coming from the victims and their relatives. Thank you very much.
Thank you, Bernard, for this very interesting presentation. So now to hear about a partner of the CIDDHU, we have Dr. Anton Burkov, who works at Sutyajnik, an NGO in Russia, where he litigates strategic cases and organizes different trainings and conferences. He also chairs the European and Comparative Law department at the University of Humanities in Yekaterinburg. He will present his experience working with the CIDDHU.
In Russian.
In English.
Спасибо. Давайте начнем. Я вам скажу.
I will translate after.
Into Japanese. Okay, well, I'm very much pleased to be back in Canada, in Montreal, in Duhaime, and in the clinic. Really enjoy your weather. First, I will say some words about the NGO that is cooperating with the clinic since 2007. That's an NGO which is already 22 years old, which was set up in 1994, first as a legal entity to help labor unions to deal with legal issues, usually labor legal issues. But then it grew into something more because labor union members do not only have problems with labor rights, but something else. And we ended up, as we are right now, we do strategic litigation cases. There are not so many that we can handle, but we carefully select them. Now, they can be from in different areas of law, but I think one issue connect all the other issues that we try to work on is the access to court, access to fair trial. And we also do work with mass media. We try to deliver the message about human rights. We try to translate all these complicated legal issues for the journalists, so the journalists can say something, say more to the public, how it is important for everybody what we are doing. And we also run trainings on human rights. And since 2011, we started this project called the Ural School for Human Rights, Ural's Human Rights School, where twice a year we invite human rights lawyers from different NGOs and sometimes advocates, our members, to be trained on particular issues. And for each school, we select a particular topic. That's what we do. And when Russia joined the Council of Europe in 1996, and then Russia ratified the European Convention for Human Rights in 1998, we started to bring cases, after exhausting the remedies in Russia, we started to bring cases before the European Court of Human Rights. And that's where we realized the need for much deeper research. And that's where we realized the need a research done in a different language than the Russian language. Because especially in the 90s, there were no materials in Russian, no translation of the case law, no textbooks. It's still very much limited, but native speakers of French and English have more access to this kind of materials. And that's where we started to look for partners who can help us with the research on cases that we are bringing to the European Court of Human Rights. And the first choice was the legal global law firms. Big law firms with offices in Moscow, for example, which could do work on a pro bono basis. And we did this first project. We were able to find some law firms which decided to help us in some cases, but we ended up not continue working with most of those law firms because we've run into two major difficulties. First of all, the conflict of interest. If a global law firm have an office in Moscow, it means they represent the Russian government, and we bring cases against the government. So the law firms just are not able to work with us, even on an anonymous basis. And the second barrier was language. We faced this issue of basically balancing whether we are going to put our work hours into research ourselves, or we will put our work hours into translation of the materials for the, in this case, law firms, and they will do the job for us. So by the time I got to Montreal in the summer of 2007, I'm lucky, I'm always coming here in the summertime, enjoying the sun, camping. I did some fishing here. So by the time I got here, that's actually a separate story that maybe to tell later, how we get to know Duhaime people. By the time I got here, I was already kind of disappointed a little bit with the work with global law firms. And when one summer day in July, I was introduced to Bernard, and we went for coffee. He was talking about that they created the clinic, and let's try to, do you have any case that which we can help you out with? To be honest, I was very much skeptical. I said, I was just nice, saying yes. Thank you for the coffee. Because I knew what kind of issues our NGO might face when working with a foreign clinic. But we started, and the first project was, I think, in 2 months. And I was able to come back again in October. Still, the weather is still nice. And where I met MJ with the first group of students, one is present here today. And we were working on a case of basically the right to association of a small political party back in 2005. By the way, this case is still pending before the European Court of Human Rights. It's already 11 years old, and we did this research 9 years ago. So the first cooperation was so easy, how can I say, which went very easy, no obstacles, smooth, right, that's the right word. First of all, I realized there's no conflict of interest. You have any offices in Moscow? Not yet. Yes, and language. Language barrier still exists, but somehow we were able to deal with this matter. And then one mission after another. I have a record of our missions from 2007 till today. There have been 13 missions so far. Some of them are in separate cases. 4 missions were on one very complicated case at different stages. And today I wanted to say, elaborate on what were the minuses and, I would say minuses, pros and cons, as it says in the program. Yes, no conflict of interest. That was important. And after actually working with UCAM, after some couple of years, our NGO started to work with law firms. But we found a law firm which has no office in Moscow. So solved the problem. What is the benefit of working with law clinic is, although this service is given for free, pro bono, from the law firm, you still have to sort of pay to the law firm by picturing the beauty of the case, attracting this very well-paid, expensive lawyers So they devote some free time, some their time for free to work in our case. Well, it means that I have to convince them that it will benefit them. It will maybe entertain them, or they will contribute to development of the Russian law, for example, or even to the development of the case law of the European Court. So it requires a lot of efforts to convince them to work on the case. With the law clinic, it was much easier. I think the team at UCAM were more concerned not about the beauty of the case, about sexy image of this case, but about a research question. How it will benefit the students, what students can learn from it. And we never had a problem with putting a research question before students. And by the way, it took me, as I was responsible in our NGO to work with you, it took me some years to actually start to put very straightforward research questions before the students. In the beginning, I was all over the place, trying to explain all the case, all the issues, no issues. But then it took me some time to understand how to do it very efficiently. So, what is important experience of working with Clinic is the Clinic. Well, this is at the same time in pro and contra. Clinic accepts missions, tasks regularly. So it's good because I know that if I frame the research question in the right way, we will have this resource available each fall or each spring. So it's very much reliable, especially after some years of establishing personal contacts with the staff. By the way, it's also a very important issue, personal contacts with supervisors. 5 minutes. So, but the negative thing about it is that, what about if the case is coming in the winter time or in the summertime? In this case, there's no way just to turn to the law firm. But I must say that we had such situations that, for example, the mission was so difficult, demanded a lot of work to do, and it run outside of the term of the semester. But still, supervisors continued, MJ, JP, and Mark recently, who continued to work on the research, trying to shape it and deliver the result that we can use. Yes, that's this term issue made us. We still have. We should remember that the most important person, legal or physical person, is still our clients. So we should remember about our clients, and this issue of terms made us think that we sometimes need to be sure that the research is done before the deadline going to the European Court of Human Rights. So sometimes maybe I'll open the secret now, but sometimes we put the same mission for the clinic and for the law firm. I just make sure that and then when the results were delivered, we would mix it together to an application to the European Court. And for example, the case can start in a spring term, so we can make an application fine, but then communications comes in the summer. So we direct this issue to the law firm. So I think that's a good way to do it in parallel sometimes. It's not often happens, but when I'm not sure we can meet a deadline, we do this. The positive thing is I think it's much more fun to work with students. I know that maybe our NGO, our case can teach something to the lawyers, the law firms, but I think it's much more effective sort of investment into students because they're young, they're fresh, they have no experience so far, and I'm sure most of the students who went through these missions will remember our case throughout their career. And the two students that we recently worked on, they were recently saw an article in Toronto Sun which talked about a case, illegal organ removal case that we worked on together, and they saw the continuation. It says that we submitted the application to the European Court, and here's the reaction. So yeah, they were very pleased to hear that, and I was pleased to hear that they saw an article about this case. Language, it's going to be always an issue because all our materials are in Russian, and we bring the case to the European Court of Human Rights. On one hand, it's a positive thing because it's much better to submit an application in English. We've never done it in French, probably because I don't speak French. But so it's a good thing that we can write an application in English. But on the other hand, what do we do if there are materials in Russian and really to write a memorandum or research, we need to translate it into Russian. In this regard, law firms are more flexible. They have no money. They can, sometimes they have a staff, native speaker Russian staff, so they can actually, not if not translate the judgment, the local judgment, but they can at least explain what is it in the judgment. Sometimes they hire a translator, and they translate the text. But in our experience with the CAM, I think a couple or 3 times you had students who at least could read some Russian and they can understand. And sometimes I would find a volunteer in Russia to translate the text into English. Sorry, I'm breaking the rule of 20 minutes, but okay, I'll, maybe during the question and answer I can address other issues, but I like the idea of Bernard about non-legal research. That's so right and important. For example, the case that we worked on with the clinic recently, 4 missions we did on illegal organ removal. Yes, we dealt well with the law issues, and it's already before the European Court. But now the most important issue of this case is there were 4 organs that disappeared from a dead person. The question is not very legal. It's more medical, more issue of transplantology. Where do those organs might have gone? For scientific research, for extracting some medicine, for example, to make people look nicer. We have no idea what's going on. We need special professionals. It doesn't matter from Russia or from Canada, but who can explain us non-legal issues. And that's the most important thing to do. Maybe we can find somebody, and one of the missions will be to do this research. Maybe pharmaceutical companies buy these organs, and it's interstate trade of organs. That's important to answer. So it's good. It's a good idea always. Come up with good ideas. Yes, that's probably the most important points of our cooperation.
Great, thank you, Anton. So we will now hear from Milton James Fernandes. MJ is a member of the Quebec and New York Bar. He joined the CIDDHU as a lecturer in 2007 and has since been working with the CIDDHU as a supervising lawyer and on and off lecturer, I believe.
It's a great pleasure to be with you folks here today, and it's a great pleasure to be sitting beside Anton. When I first met him in 2007, along with Mathieu, it was Mr. Burkov, and now it's Dr. Burkov. And if you ever want to see someone playing out their doctoral thesis before the courts, Anton gives you a wonderful example of someone that's picked a problem, right? Implementation of the European Convention in a challenge to Russia, right? Understanding procedural rights, substantive rights, and doing it with partners, right? Taking the time through clinical legal education at an NGO with a beautiful name, Sutyajnik, which means vexatious litigator.
I'm not sure about this word. Litigator.
Malicious litigator. Partie vexatoire. So what a beautiful name of a client to be working with. I might just add to the introduction. I came to, I guess, UQAM in the same capacity as Anton, as a client when the clinic started. Right? I had been introduced to Professor Duhaime by our current dean. He and I shared a moot experience in perfecting our legal advocacy in both written and oral format as students together. And many years later, at his wedding, actually, he introduced me to Bernard Duhaime, and he was telling me about Bernard coming back to UQAM to start up a legal rights clinic. And on the Quebec landscape, that was incredible. There's a law here, the droits, that restricts the ability of students to engage in clinical work. Right? In the United States, in Ontario, there are far greater opportunities for students in a law school setting to engage in exactly the type of work, advocacy, written and oral, right, on behalf of clients directly. We're a little more restricted here, so why not do it internationally? Right? Milton had come with Talon Hinding at the time and set up this clinic, and it was revolutionary to allow opportunities for students to get involved, to research and work with advocates. So I came as a client because at the time, and I'll share this with you, at the time I had a mandate that related to the assassination of the former president of Burkina Faso, Thomas Sankara. Thomas Sankara had been assassinated in 1987. Some people call him the Che Guevara of Africa, and at the time they had produced a death certificate for him that said the man died of natural causes. That death certificate remained in place. His family fled the country, and some lawyers there were trying to shed light on the rectification of this death certificate and maybe the cause behind the demise of Thomas Sankara. Around 1999, Burkina Faso signed the International Covenant on Civil and Political Rights, and someone asked me the question, this event back in 1987, do you think we could somehow deal with this now? Assuming there's a problem with retroactivity, right? Retroactivity of the convention. We said, well, there's no reservations by the state party, so let's give it a try. We forced the courts of Burkina Faso to exhaust local remedies, going through a whole list of procedures, and we managed to get the UN Human Rights Committee to recognize that surviving members of the Sankara family, his wife and his children, had a right to know the circumstances of the man's death, even though it had happened many years before the Sinai Convention. That created a window for events, I guess, that would have unrolled last year and this year, where the actual exhumation of Thomas Sankara's body took place in Burkina Faso. They've identified that he didn't die of natural causes, and they've issued an arrest warrant for someone they suspect was involved with that many years ago. The reason why I tell this story is because it took many novel arguments to get around a very complex issue of asking what is the appropriate remedy. When you have violations that occur in this modern time that you can point to, what is an appropriate remedy? And it's only with the work of students at the time from McGill and students from UQAM that we could go through several arguments that were put forward by the state to ask ourselves the question, would compensation apply? Would a conseil des sages, a wisdom council talking about issues apply? Could these issues put in front of military courts where the public wouldn't know? These are very complex issues, and it took many hands and many people to contribute to that result. Right? Now, I say that because Anton and the collaboration we've had with Sutyajnik have given us many opportunities to grow and to hone our skills as advocates, right, as students, and really as people who are cooperating to articulate test cases with the partner. Right? Mary earlier had spoken to us. She says, are international human rights clinics the new NGOs? And they might be in respect of certain things, I submit. And the experience with Anton, I think, speaks to that notion, right? That we can work together to create test cases to implement laws, in this case the European Convention, right? And to identify blockages to the materialization of rights. Right? If I may, Anton made a comment that he said at the beginning we had a challenge of articulating what the research mandate would be. And I think that's entirely true. And it's taken 13 cases to get to a place where we can work together and identify issues and say, here's where we're going to go. Right? And we can shoehorn them, in our case, into 14-week periods, right? To try and respect the student schedule, the university schedule we have, to give a meaningful experience to students and a meaningful full product to the client that they can turn around and use, right? If it's to confirm their own research, that's useful, right? If it's to challenge the research and expand the mandate, that's equally useful. But it's only by being present, being mindful, and being engaged that you can accomplish that, right? So one of the things I might add about the participation that I've had with Anton is Anton innately understands the notion of test cases and the notion that you have to pick the right claimants. Right? This is a lesson, I would draw back to the US civil rights experience that was learned and implemented in the Brown versus Board of Education, what's known as the separate but equal busing case. Right? In the United States, there was an issue of children being segmented along race to go to different schools. And certain people, advocates and human rights folks, got together and said, we've got to pick the right kids who are strong enough, right, who have the support, who will be in a position to go through what we're going to ask them to do. Right? And it's because they picked the right people and they eliminated the circumstances that would offer additional challenges or make them fail, right, that they were able to bring those cases. Right? Anton brings us many surprises, right? And challenges, but I think innately he understands that we can identify claimants, right, to identify issues, and then somewhere we'll get to raise other issues that we can bring directly in front of the courts, right, in Anton's case, and ask why is this being done in a certain way. Now, if I may, Anton, I'd like to speak about the license case, right? Because the evolution of this case, I'm calling it the driver's license case, a duplicate case, right, shows and illuminates two themes that Anton has raised, which are current challenges in the judicial system in Russia. One relates to journalists and their sort of access to the courts as third parties, and the other relation to fair trial protections, right, the openness of trial or procedures, right, that would allow us to say that fair trial is actually an important principle in Russia. Anton came to us and said, I've got this young person that has a license, right? And that young person has lost the license, and they want to get a duplicate copy of it from their local registration. And because of the old Soviet system of propishka, right? Propishka was a control mechanism under the Soviet Union, where you had to stay in your area, you needed permission to move out. Your mobility and your ability to do anything was controlled locally. So the propishka system still had a headache, still had a hangover, a residue that was available administratively, and it manifested itself in the simple act of someone asking for a duplicate of their driver's permit. So he has a young person who lives many kilometers away that would have to travel to go and get a duplicate driver's permit. Very simple thing.
2 days travel.
2 days travel, so something unreasonable, right? In an age of internet, of mail, we still have an element of this ancient relic of the Propiska in place. So Anton filed a case, and as his case was going through, a very simple thing, we came upon different judicial obstacles to having fair trials and having a functional system in Russia. One of the things that Anton was able to identify is that certain decisions, right, judicial decisions upon which judges may decide, are not actually published or available. In common law, we talk about precedents, right? In order for a precedent to be available to rely on, you have to be able to find it. You have to be able to read it. It has to be published. Well, apparently not all judgments relied upon in Russia are published, and there's no law that requires it. So Anton identified that. A judge sitting in chambers can make a decision that would dismiss a claim, and that's considered lawful. Enter Anton's thesis, right? The notion of applying the European Convention. Right? Anton appealed that decision on behalf of the client, went to the Court of Appeal, and if I'm not mistaken, you showed up and they said, hello, thank you for coming, we're going to go make our... They didn't say hello. They didn't even say hello. They said, we're going to make our decision. I didn't even say you're welcome, right? They didn't even say you're welcome here.
And then I said, wait a minute, we're here to give our opinion. And they continued to the chamber, and then came back and delivered the decision.
Imagine that.
And they finally I said, but wait a minute. And they imagine what they said. They said, we didn't invite you.
Anton is the lawyer representing the client. He has no substantive rights on appeal on behalf of the client. Well, if I may, one of the, as Anton's working his way through the system, you can see what he's doing. He's exhausting local remedies, and as he's doing it, he's finding more violations. If I can speak to when you file the application to the Constitutional Court, right? By some accident, and I don't think it's an accident, I think we've been working together for a long period of time, Anton filled out a form saying there was violations in the first instance based on secret evidence, right? The audi alterum part of the right to be heard was abridged by failing to hear the arguments and present an adversarial argument. And for some reason, he put his name as a claimant on that Constitutional Court document asking for relief from the previous two decisions. When Anton told me that, I said, that's interesting because you're a lawyer and it seems like you've been prohibited or prevented from doing your job because they won't allow you to speak in front of a judge. That makes you a victim. Can I be your lawyer? I asked him. He said, sure. So I got to work with Anton as a client because his rights have been abridged in the complaint before the Human Rights Commission. And he's got these issues in terms of the publication of judgments, the rights to audi alterum partem, and the issues related to access to courts, right? In terms of the functioning of the judicial system, squarely in front of the European Court now. A simple case related to the duplicate of licenses, which doesn't really threaten anyone, right? It's a simple administrative thing, has now allowed him to put these very big structural issues squarely in front of the European Court and hopefully to be dealt with, because we know they're not being dealt with by Russian courts. They haven't yet gotten past repeating the things that they've done for many, many years. Right? So I look at that cooperation as an opportunity that evolved out of many years of us working together and being in a position to articulate a problem and then have the flexibility to identify further issues during the course of our work. So I would give you that as an example that if any of you engage in this in different places, I would hope that you would have the personnel, right, and a partner that you can develop this relationship with so that you can come to that point where you really get to name the name or name the problems that are structural, right, and put a legal argument on them and have courts adjudicate on them when you're not dealing with a court system that's cooperating. I would stop here because I think our discussion will give us more occasion to discuss. I noticed another member of our first team just came in. That's Rami over there. He's two of the three first students that we ever worked with Anton. So we're hoping for a last one here so we can do an updated photo. The first time we got to work with Anton. So, thank you.
Thank you, MJ. Many thanks to our three speakers. We now have, I would say we started late, so let's say about 10 to 15 minutes for questions, discussion. So please, if you do have questions, identify yourself. We don't have a mic going around, right? Okay, so just be loud and project, please.
Or we can have lunch.
Lunch is waiting, but I would encourage you to.
Maybe while somebody is coming up with a question, I can add to what MJ just said. It's interesting that this case, the main issue, although the court didn't give us a chance to go through the courts and challenge the issue of no issuing duplicate at the place where we lost it. The government actually changed this rule 2 years ago, a year ago, so 2 years after we brought the case. So there was a problem, and they recognized there was a problem, but they didn't want to go through the shame of the court and recognize it by the decision of the court that there was a problem. But when litigating this case, we found so many other issues with the legal system, and I think it's the most important probably point when litigating a case strategically. You should not be short just looking at the particular issue, but you should open your mind and see around what is wrong with the system, why you have difficulties to litigate this case. And the same happened with Sabina versus Russia case on the illegal secret organ removal. With the clinic, we already had 4 missions on this case. So there's a main issue of organ removal, and then the participation of the prosecutor, and then access of journalists to the court hearing, and something else. So by litigating one case, you see so many issues, and you have to work on this because that's important to solve them.
Unless there's a question from the floor, there was something I wanted to add with regards to the impact of clinical legal research. Of course, our topic was the relationship between the projects and the partner organizations, but let's not forget that, and I know this is for another colloquium, but apart from legal education and its impact, the clinical legal education and its impact on the techniques and the abilities for students and so on, I think the creative process that the collaborative dynamics of action-based research requires also has a specific impact on students, on how to frame a question, on how to find the obstacles, not only in the library, but also in this type of cooperative initiative. And that's relevant for students to be faced with these challenges, and they learn to do research differently. And I think clinics need to invest a little bit more in that. The CIDDHU and the Clinique at the Université Laval have been doing lots of events where students and former students have the opportunity to present their research, not only their clinical project, but also what they have been doing extra after the project. They've been doing an internship, they've been writing an article, they presented a report, And I was last week in Geneva to work with the working group, and I met with a former student of ours, Audrey Mackay, who now works at the ICRC, the International Committee of the Red Cross. Well, she's working on projects dealing with natural resources, among other projects. But this is an expertise that she has developed through a clinical project with the Due Process of Law Foundation in preparing a report with the Clinique of Texas University, which is led by another member of the working group, which is it's kind of funny. And this report was then submitted during a hearing at the Inter-American Commission on Human Rights. Then Laval University did an event specifically on this and read the report and said, hey, this is great work. This is scientific production that deserves attention. And through a colloquium that was not for students only, it was a colloquium for experts, they asked Audrey and her colleague to come and present as an expert on this topic. And her report, and the Clinique's report now, is one of the few resources that exists on the topic. It's being read, it's being consulted, and Audrey has been able to put to use this professional legal research experience to the benefit of the pursuance of her career as a specialist in international humanitarian law, now at the ICRC. And we need to value this. I think that our efforts and the originality of our legal research and the process of finding questions and the process of finding answers and the collaborative initiative behind all of this work with the partner organizations has much more impact than we think on our students. That's why I was emphasizing earlier that we need to think more on how we can link the students' research experience during clinical projects with their graduate studies projects. These projects can be followed up as a thesis, a doctoral thesis, LLM thesis. Why not? These are all projects that could eventually raise interesting questions that would deserve 2 or 10 years of research, and it's a great way to explore these human experiences of social justice and taking it to the next level.
Thank you, Bernard. Do we have any questions? Yes, please.
Hi, I'm Langlois. I work at Milton University. I was collaborating with the Clinique on a objective report for New York. So my question is, Russian high-level politicians sometimes threaten that Russia may exit also Europe. Do you think this is a real threat?
And perhaps how would this affect your work and your reliance on the European Convention, if I may add?
Or your retirement.
No. I guess you're referring to the recent examples of this kind of threats, opinions. Remembering the history of Russia working with the Council of Europe since 1996, especially in the years of 2000 until today, it's like ups and downs. Before the first judgments against Russia, the cooperation was very smooth. Fine. Nobody blamed Russia for any violations so far, so we're good collaborators. Well, there were Chechnya in the 90s, and the Russian delegation was asked not given rights to speak at the parliamentary assembly. But then there were a period of good relationship. Then there were new first judgments against Russia. And one important case of extraterritorial application of the European Convention in Ilashku versus Russia case in Moldova. That's where the relationship degraded. And this was like this. For example, in 2006, Russia didn't, the only country which didn't ratify Protocol 14 of to the European Convention, which greatly reformed the European Court. For 4 years, there was no ratification, and that means that the protocol couldn't start working. And then Russia ratified it, and Russia became a very good friend again with the Council of Europe, and that was like this. The recent judgment by the Russian Constitutional Court of 2015, which says that the Constitutional Court may rule that a particular judgment of the European Court of Human Rights is not applicable in Russia. Well, that's nothing new. There are so many judgments which are not being applied. Yes, they pay compensation, but they, for example, do not do investigation, they don't reform a particular federal law. It wasn't for a professional who was involved in this kind of work. It's not a surprise what the Constitutional Court said. In 2015, they just became very honest. They said, well, we might rule not apply a particular judgment. Speaking about leaving the Council of Europe, I don't know if it's visible in the future. Still, those politicians who say it, if you look at their property outside of Russia, you probably think, well, they probably need a visa to go to Europe. That's why they will never vote for leaving the Council of Europe. Or some other issues to be taken into account. It's much more important to understand. It's important to understand what they say publicly and what they really think. There was one person who is a deputy of the State Duma, who's always speaking and have this rhetoric, anti-European Union rhetoric. But I recently met a man who knows his family and who told me how many real estate property he has in Italy, for example. So I hope these threats will never materialize, because I think who will lose because Russia might access the Council of Europe is the people. Quite often, the only remedy regular citizen has is to go to the European Court and at least get an announcement in the judgment that there's somebody did wrong. The Russian government, prosecutor, or the judge was wrong. It doesn't matter about the compensation, not that big. But it's important for a victim to get this official judgment saying Russia did something wrong.
Thank you. We have one more question from Yekaterinburg.
Yes, thank you to all three of you. I learned from Anton that sometimes you actually work in parallel with law firms and the clinic, which is something I didn't know. So I was curious to know what's the difference in what is delivered and the results that are delivered. What's the difference in the ways we work the mandate? You know, on the one side you have professionals in the law firms who will work on the same question as students who don't have much experience in international law. So, yeah, I'm just curious to know, you know, what do the results look like? What's the difference between what you get from the law firm, what you get from the clinic, and then how far does each have its
well, first of all, it doesn't happen often. And actually, in the recent 5-6 years, we didn't have a duplicate of the mission. It's only in the beginning when we just started to cooperate, and I was really worried about deadline. Yes, so that's where we decided with our director that let's do it 2 ways, and then we'll see. It was more work for us because he produced wonderful mandate, and it was by the way Mikhailo case. And the law firm produced a good mandate, research, so we needed to combine it in one application. But that's turned into a good thing because later, when the case was communicated, I think it was this summer, so we went with the law firm to do the communication. What is the difference? I would say, well, because the law firm, they're very much skilled in legal research, and I think they come up with research much faster. The writing is more polished, maybe. But what I like about the clinic work, it's more, the communication is more alive, and the students are more open to new ideas. Like, for example, you described the example of putting your own name in the application to pursue these particular issues. Lawyers are not very much, lawyers at the law firm, they're not very much open to this kind of jazz. Even this, the format that we're creating, with law firms, we never have Skype conversations. It's always conference calls. The quality is so bad. I never see faces. With law clinics, it's always Skype. I always see faces. I might not remember them later, but as I already mentioned, they have more resources in terms of translating some texts. But actually, by the time as we learn how to shape the research questions, I realized that quite often you don't really need to translate any local judgments, because usually those judgments are of a very bad quality. You don't know, you have to know them. I can just restate what is inside, what is the main point. What else? I think that the most important difference is quite often we cannot find a law firm to work on the issue because they think it's not sexy enough for them. They're very important to spend time on not very interesting, from their point of view, research, legal issue. That's probably the most important points.
Yes.
I will just add one small little thing, and then I'm sure we're all very hungry. I think we also need to think outside the box in terms of developing the type of partnerships that we build. Our projects tend to fall often in the same ballpark with similar regions and organizations that can provide us with challenging projects for students. And of course, our role is to assess the pedagogical value of these projects. Now I realize that the special procedures in the UN system, which is much more informal, I guess in certain ways, and does not depend on ratification of instruments, allows perhaps for very creative projects by clinics in areas where perhaps we would not have the reflex to look, because these are areas where perhaps collaboration is less easy. But believe me, there's so much work to do in Egypt, in Pakistan, in Bahrain, Saudi Arabia, China, in Iran. That's just talking about countries that will have the capacity to address an issue. Then there are all those human rights defenders in countries where we don't even know how this could be done. Sudan, South Sudan, Eritrea, Yemen. Perhaps we need to get out of our comfort zones and start looking at what is being done in different ways in these countries. Of course, it will not be written, human rights NGO, please come and take me to jail on their business card. But maybe they're an environmental or academic liberty organization that we could look into these new types of partnerships. Also, there are countries that are changing, and perhaps it's a good opportunity for clinics to develop new partnerships. Myanmar is changing, Sri Lanka is changing. There are opportunities for clinics to strengthen the civil society that needs to develop itself in a new environment. Perhaps these will raise interesting legal questions that will benefit both the partners, the clinics, and the students.
Great conclusion, Bernard. So please go ahead to our So lunch will be served. We will be back at 2 p.m. For those of you with like CLE credits, formation professionnelle continue, the list is here. And for those of you who would like to support the clinic's work, we also have the forms in front. Thank you.
I would invite, sorry, just 2 minutes please. I would invite all the speakers for lunch in the back room, and then we will be back at 2 for the rest of the conference. Thank you.
J'avais